This was ripped off from a title of a podcast series by the Washington Post called "Can He Do That?" I changed it to "they" for a meeting to broaden the concept and the U.S. Constitution in today's America. Some housekeeping items. Cell phones should be, in the vibrate or off position. We do have a class website. I encourage you to look up the URL that are in our little flyers outside or in the, because they have materials for the class, including a copy of the Constitution. And other documents we'll post over time. And as we do videos, we'll post the videos once they are through the editing process. We do a slight edit at OLLI, but it takes about a week before they are ready for posting. If you're not on our mailing list or you added your name to the mailing list but you haven't received anything from me, it may be because I couldn't read your handwriting. Try again. A little bit about me. Many of you already know background in academic background in government and public administration. I love American history. I love history in general, American history in particular. Any new members in this class that we should introduce? Any new members? Just a bunch.
New to this class.
Just a bunch of old members. Okay. Just a comment. Again, we're videotaping this. The videotape will be posted on our website for the class, but also on the OLLI website, which is under the classes activity section of the OLLI website in the distance learning video section. So you can come back and critique what we did, and for those who can't come or you'd like to have them sample the class, they can go see what it looks like. This class, while contemporary to our times and the issues we present, is a little bit less ripped from the headline as our Money News class and our Trump presidency class. Thank goodness. I only had to get up at 5:15 today instead of 4:15 that I normally do on those other classes. So thank goodness. Okay, let's get started. Let's start with the oath. The oath that we swear to, we have our federal, state, and local officers swear to. And think about that oath for a minute, and let me help you think about it. We have our officers of the federal government swear to defend and uphold the Constitution of the United States. It's not to the head of state that you might take an oath in a country with a queen or a king, a royalty. We don't do it to any officer of the United States, state government or local government. We swear to uphold the Constitution. And we do that also as civic officers. We swear in California to uphold the Constitution of the United States, as well as in the case of California officers, the Constitution of the state of California, but the federal Constitution is the preeminent one. So think about that. This is as sacred as a document as we have, the Constitution. It is what we send people in harm's way to defend. The Constitution, our form of government, our republic. What is this class? Well, this is a class on the Constitution, both what's in it, how it has evolved over time, and how it affects the separation of powers and the outcome of a number of contemporary issues that faced the nation. Whether it was the issue of slavery in the 1800s, or more recently in terms of what constitutes a marriage in more contemporary times. We're going to use some videos from time to time. Not so much in this series we're going to do in the spring semester, but definitely in the summer semester. We are blessed with a number of guest speakers in the spring semester, and it's my belief that that's a great way to start this class. A typical class, we talk about some constitutional issues in the news. We do a history lesson from a video. We have a variety of videos. One's on the adoption of the constitutions and the great debates in the ratification process in the Constitution, the history of the Constitution over time, and of course, the interpretation of the Constitution by the Supreme Court. And we'll get right into the words and meanings, but we'll do that in bite-sized portions so that we can understand the concept. We'll also look at the limitations and powers placed on each part of our government, and which powers are taken back from governments that they can't exercise. The great struggle between the branches and the states and the people that has been the history of our republic. And of course, we'll look at contemporary constitutional issues. I'll use a number of primary sources to help put together the class in addition to the videos. One source I'll use a lot is the National Constitution Center in Philadelphia, a nonpartisan, nonprofit organization set up to assist in the education of Americans and others in our form of government. It's a great place to visit, whether you visit online or in person. In person, you're run over by kids, doing scavenger hunts, trying to find this piece of information and that piece of information, but it's joyous to see them. We'll also look at some alternate sources, such as the Conservative Federalist Society that is very much in vogue these days with the current administration in the selection of judges. And there's a number of great podcasts available. We the People from the National Constitution Center, the Washington Post series, Can He Do That? And one I think is a great way to understand the Constitution, a limited run podcast that was done in 2017 and into 2018, also from the Washington Post, but without, I think, editorial bias, called Constitutional. A set, I think, about 10 or 12 talking about great moments in American history, whether it be the issue of slavery or just the issue of gender rights, the war power in our Constitution, just a lot of stuff. Also, I listened to SCOTUS cast from the Federalist Society.
Are all of those on the website for us?
I think, yes. I believe I have all the sources in it. So today we're going to talk about constitutional issues in the news, a history lesson, sanctuary cities, talking about constitutional boundaries with Dr. Robert Robertson from the Political Science Department here at Cal State. So let's get started on In the News. Just the last week, and just surveying the press, what are some of the constitutional issues occurring right now in American society? Well, the Supreme Court stayed the start of the imposition of a Louisiana state statute on abortion. And that statute would have the practical effect of limiting the number of doctors that could perform abortions in the state of Louisiana to 1, from 3 now, until the Supreme Court decides the issue, until the local appellate courts decides the issue and then be brought up to the Supreme Court. The Supreme Court decided not to take action, apparently for this term, on the constitutionality of President Obama's DACA policy, and in effect leaving the stay, the injunction against ending it in place, meaning that it's going to be around unless the Supreme Court does another action for its entire 2019 term. A judge down in Florida said the state went, or a local law went too far in limiting and restricting the ability to do so-called, what is it called, conversion therapy, and that is usually a faith-based program to realign someone's sexual identity to their birth gender. Said that the government couldn't outlaw that form of therapy under the First Amendment. This may be the biggest political case this year, and that is the case on who is going to be asked the question of, are you a citizen of the United States in the 2020 census? It has not been included as a question to all respondents in recent censuses. And under the Constitution, apportionment of the legislative districts, the congressional districts, and by virtue of the 14th Amendment, state and local districts is based upon population, not citizenship. Population, not citizenship. The fear that those on the left see, as opposed to those on the right, see is if you ask the question, people will avoid being engaged in the census. And not only do you have political power apportioned through legislative apportionment, you have dollars that are sent from the federal government to the states and from the states to local entity as well. That's a key decision working its way up, or a key case working its way up as to the constitutionality of the exercise of authority by the President and the Commerce Department. And of course we have this Texas decision, that injunction against Obamacare, that basically said when Congress took away the mandate for individual coverage, it undermined the whole law legally, since the Chief Justice in the majority 5-4 decision based the constitutionality of Obamacare on the taxation penalty of individual coverage. Lawyers will argue that case extensively. They said if there's no penalty, no one can sue on it because no one has legal standing to sue. So it's an interesting case. That decision has been held in abeyance as appeals go up to the Supreme Court. So that's just a few cases very recently. But I think it's important to start a little bit about what's the circumstances that led to the adoption of the Constitution. I want to give today the short version. Over the next 8 classes, or 2 more this semester and 5 in the summer semester, we'll go into it in detail. But a short history to recall to your attention. I don't think any of us were there. Let's see. Maybe you. Let's see if my DVD player, this is multimedia for me. Let me see if my DVD player works. Oh, by the way, before I start that, not a great picture. I think I was a deer caught in the headlight. But this is where the Constitution was prepared, in Independence Hall in Philadelphia, in this room. And what you're struck by when you're in that room is how small it is. How very small all these great people of American history sitting down trying to hammer out a constitution in secret, knowing that if the word got out beyond this room before there was a consensus, that it could sink the whole enterprise. It was in that room. You see where the kids are in the background in this picture? That's almost the extent of the room. Very, very small room with no air conditioning. So when they put down those windows, it got very hot in Philadelphia. Any of you who've seen the play or the movie 1776 knows that the heat and humidity there were the history of just the ratification process. In any given state, it was a close call. It was a close call in Massachusetts. It was a close call in Virginia. In New York, it seemed like it was an impossible obstacle to get ratification with the governor adamantly opposed to the Constitution. But it showed even in those days that there was an inherent ability in Americans to legislate and deal with the democratic process of getting a majority, the ability to trade ideas. At first, they didn't want to put in a Bill of Rights because the thought was a Bill of Rights would restrict the rights of Americans. If you indicated one right and you didn't indicate another right, the assumption was you didn't have the other right. Government, the Constitution should only be focused on the limitations of government or the specific functions of government. And we'll go into that during this series of classes. So let's look at some of the key points from what are essential for our understanding today. Let me get back into slideshow mode. If you go on to the National Constitution Center website, it describes what the Constitution does in a few bullet points. And I think the video does a good job. But as highlighted by the National Constitution Center, the Constitution established a government that puts the power with the people, not with a monarch, not with a hereditary line of chiefs of states and chief executives. It separates the power of government into branches. It sets up a set of checks and balances. And that was a concept that had great philosophical bases at the time in the Enlightenment period. But in practical terms, this was something still really to be adopted somewhere. Divided power between the state government and the central government. It describes the purposes and duty of government. It defines the scope and limits of government power. It prescribes how representatives are elected. It establishes the process for how you ratify the document, and it outlines rights and freedoms of the people. It did after the first 10 amendments and subsequent amendments. But a key concept today, constitutional concept today that I want to go through before Professor Robinson shows up. And there he is. Boy, this is timely. Professor, why don't you come right down here? I'm about 5 minutes before introducing you, but let's introduce this outstanding professor from Cal State Fullerton. You sit over here and I'll do a formal introduction in a moment. Kind of set the stage for you coming in. Federalism, the division of power between one government and another government. the separation of where authority lies. And in our form of government, we see that primarily at the federal and state level, and to a degree at the local level. The local state separation is not nearly as clear cut, because under most state constitutions, local governments is a subdivision of the state, not a separate entity, though some states have what they call home rule. And there's two key amendments to the Constitution. It really sets out the principles of federalism. The Ninth Amendment that says powers not enumerated in the Constitution are left to the people. And very importantly, the 10th Amendment, that the powers not delegated to the United States by the Constitution nor prohibited by the states to the states are reserved to the states respectively. Now, those are general concepts, but over the course of our existence as a nation, those clear cuts, what rights are reserved for the people, which ones are reserved for the states, which ones are shared, and which ones are not to be had by anyone, have been issues of great conflict. And to discuss one of those areas today, we have a member, and we're proud to have a member from our own university, of the faculty of this university, to talk about the division and sharing of powers between the state and federal government. And with that, let me bring up Dr. Robert Robertson, Assistant Professor of Political Science and Department Coordinator of Political Science. Doctor, I'm going to yield most of your time just for you to make a presentation. I have a long resume on you. Okay. Let me say, this guy is very well qualified. Let's welcome him, and we have to kind of put two microphones on him, one for our videotape and one so you can hear it. So we're going to take a 1-minute break here. Hold on.
All right. Good morning, everyone. So I feel a little bit like a robot wearing this, but hopefully that will just keep me on my toes. I appreciate everyone having me out today to talk about this. So thank you very much. So the topic for today was federalism, and we talked about topics that might fit that well. And I thought that since California and the discussion of immigration and so-called sanctuary cities are in the news a great deal, that this will be a good way of looking at some specific problems and issues in the area. By the way, my name is Rob Robinson, in case that didn't come across the first couple of times. And I teach American government, sometimes in this room, to people usually less interested in what I have to say than the rest of you. And I also teach the Bill of Rights and constitutional law as kind of my general rotation. So I will say right off that I know more about the constitutional aspects of the immigration debate than immigration policy per se, or federal immigration statutes. So be gentle, please, if you go into that area. So the issue of immigration has been a pretty big deal, at least since Trump was elected, and really before that. But I would say it's come to a fever pitch. Trump ran specifically on limiting immigration in some sense, particularly illegal immigration, but also in some sense desire to limit legal immigration. California, as a liberal state, at least in terms of who runs the government, and as a state historically with a lot of immigrants in it, has emerged as sort of the foremost state challenger to the Trump administration. So again, since we're from California, this seemed like a good topic to choose. Now, the topic here is sanctuary cities, and that's sometimes how this debate is labeled. But in some sense, it's a lazy label that doesn't tell us a lot about the actual policy debates. Because if we're to discuss the concept of sanctuary from medieval times, it literally meant that a criminal could go to a church and hide out and not be arrested by the crown. That's not what's going on here, right? If the federal government has a warrant for you. You don't get to go, well, I'm in LA, too bad. Federal law doesn't apply here. That's not the issue. So I want to look at two more specific issues that have been in the news recently and also have generated court cases at the federal court level that I can read and then tell you about. Right? They're pretty long, so you can thank me after this is over, having put in that work. The two basic things I want to look at, because they've affected cities and localities in California and generated some controversy. The first one we'll look at is the Trump administration's attempt to put restrictions on money given to localities, generally cities, that if they didn't abide by the Trump administration's interpretation of immigration laws, they would lose access to that money. As we'll see in a second, that's actually a fairly common way of the federal government trying to get the state governments to do something by putting strings on money, because states and cities always want money. They need it, right? And we'll talk about that. For the most part, the courts have ruled that Congress, not Trump and his administration, are the ones that need to set these conditions. We'll talk about that in a second. The second thing we're going to talk about is, rather than the Trump administration's attempt to pressure states and localities to adopt immigration positions that the Trump administration wants, we'll take a look at California's response, statutorily, to the debate itself. So California has not remained idle or just sued the Trump administration, although they have sued the Trump administration like 50 times. Right? We are what Texas was during the Obama administration. Right? But California also passed, in particular, 3 laws over the past 12 to 18 months that were recently ruled on in a case just about 6 months ago. And we'll look at that. And the basic takeaway here is that states have pretty good authority to control their own police force, their own workers. When they start limiting federal access to employers or the labor force, then it gets into a bit more uncertain ground. And I will say now, before I go on, that if the Supreme Court does take these cases, I have no idea what they'll do. I stopped making bets about politics after 2016. I literally lost money on the election. Okay, the basic conflict here in constitutional terms is this. California is going to argue, it has argued, that the federal government can enforce federal laws. That's their job. But what the federal government should not be able to do is to force California to carry out federal laws. And that's an important difference, right? Congress has the power to regulate the economy, for example, or regulate civil rights, but typically, as we'll see, the rule is going to be the federal government needs to provide its own bureaucrats, its own bureaucracies, and not force states to do its job for them. And that's what California's most basic argument here. Nothing is that simple, but I'm trying to distill this down to its general points. The United States, by contrast, is arguing that what California is trying to do is not just not help, but actually actively impede the federal government from doing its job. Or in some cases, the federal government has argued that the federal government has preempted an area of policy. And what that basically means, without getting too deep into the weeds, is that there's some areas of policy where the federal government is understood to be in charge, and immigration is one of these, and that states don't have the ability to regulate an area that the federal government is supposed to be in charge of. So maybe you can already see what is the difference between not helping and impeding, right? Those terms are in tension. If my children are not helping me do something, I might say that they're impeding me from getting it done, right? But we have to have a way of distinguishing those two concepts. So let's talk a bit about the actual provisions of the Constitution that come into play here, and briefly how the court has interpreted some of them. The basic debate in terms of the sources of power that each California on the one hand and the US on the other rely on. The United States tends to rely on its statutory powers and presumed constitutional power to control immigration, right? Something that you may know, you may not know, because it's not obvious from the way our government looks today. But the way that the US government was set up was that the US government is only supposed to be able to pass a law if that law is furthering something that in the Constitution. So Congress is given a list of powers in Article 1, Section 8. Coin money, create an army, build roads, hire postmen, hunt pirates. That's a fun one. Importantly, regulate interstate commerce. And so if one of these powers is in the Constitution, then Congress is authorized to pass laws on it, and typically is supreme over state attempts to do that. So a lot of what con law is people arguing about, does Congress actually have the power to do X, like the Affordable Care Act, right? Was that something that Congress is constitutionally authorized to do or not? On the other hand, states typically rely, as the introduction said, on the 10th Amendment. Let's look at these two sections in more detail. There's not actually a clause in the Constitution that says something as clear as the feds are in charge of immigration policy. It would make sense if there was. There's not. But for a long time, I'd say at least 100 years, the Supreme Court has inferred from the Constitution that the federal government is the one that should be in charge of immigration policy. Congress has the ability to regulate interstate and international commerce. Congress has the ability to decide who can become a citizen or not, which seems pretty closely tied to who can come into the country or not. And there are also sort of a natural law type argument that the feds should be in charge. And what do I mean by that? Well, the courts have basically said that the nature of a country says that the country should be able to decide who enters and leaves. That's part of what a country is. And so just in the sense that, a country has to have a, national defense, country has to be able to regulate its borders or who enters and exits, and it just sort of makes sense that's the federal government. Like I sometimes ask my students, give me a policy and tell me who should be in charge, states or the feds. A lot of my students are, liberal and don't like the Trump administration, say California should be in charge of immigration law. And then I'm like, well, how would that work? Right? People come into California and go to Ohio, right? So it's just kind of a logical axiom almost. It makes sense that the national government would be in charge of immigration policy because it's not clear how a state-by-state way of doing it would operate. Okay? And an example of this, about 6 years, time flies. There was a case in Arizona. You may remember this law. I think it was pejoratively called the Papers, Please law, which whenever you're like making an analogy to a Nazi or totalitarian government, that's a bad framing, right? But basically the argument was that Arizona wanted to create tougher immigration standards than the United States wanted to do. They wanted to authorize local and state governments to request more identification. And the court basically said, hey, the US is in charge of immigration rules. You can't just add on your own because you want to. If you don't like immigration policy, elect a different president. Right? Okay, so that's that side of the equation. On the other side of the equation, you have the 10th Amendment. So I have the text here. I'm not going to read it to you again. I don't actually know what this is supposed to mean. One of the reasons that I have a job is that when you look at the constitutional text, you don't magically get the right meaning of things, right? The First Amendment's free speech clause says Congress shall make no law, basically saying that if I knew the location of a special forces outfit, I could put it on Twitter. I would go to jail for that, right? So the Constitution actually isn't always clear in the text, and the 10th Amendment is no exception. It seems to be saying that states have retained some degree of autonomy and sovereignty in our political system. That the relationship between states and the U.S. is not, as you pointed out, the same as the relationship between Orange County and California. If California wanted to rename Orange County Blue County and then redraw all the lines, they could. States are sovereign with their own borders. By contrast, in the United States, states retain some power, right? Congress can't tell California to move the capital to San Diego. I don't know why they would. But I've actually never been to Sacramento, so I have nothing good or bad to say about it. Okay, so this has been sort of like a lot of the constitutional text, it's been a bit of a cipher. Conservatives tend to read it as a greater limit on the United States than liberals. But this is one of the policy areas where that usual dynamic is flipped upside down. Here it's the liberals that are relying on states having more power, and it's the conservatives, and by conservative I just sort of mean like Republicans supporting Trump. It's actually more complicated than that. But it's the Republicans that want a stronger federal role, right? So a principle that we can draw from the 10th Amendment, that courts have drawn from it, that's very important in this particular policy area, is something with the really awkward name of anti-commandeering. It's exciting, isn't it? But anti-commandeering just goes back to what I already said earlier, that if the federal government wants to do something within its own constitutional authority, it can't make the state do it for them. The feds have to actually go out and do it. They have to bear the cost. They have to raise the taxes. They can't use the states as sort of a subservient second tier of bureaucracy. And this line of thought in these cases were actually developed in the 1990s by the Rehnquist Court, which was trying to carve out more protection for states against the federal government. So I don't know if it's ironic or whatever, or it's actually the way federalism works. Generally, neither party is that principled about federalism, right? When Republicans are out of power, they're all about the states, and Democrats are all about using the federal government. And then when Republicans have control of everything, and then Democrats are the one talking about states' rights. And that's pretty normal, right? If you expect politicians to be principled on a principle rather than the principle of being reelected, I have some news for you. But there actually are some good, whatever you think of any specific policy, I think there are some good reasons for this anti-commandeering doctrine. Number one, you want states to retain some autonomy, and if they can simply be ordered by Congress to pass a law or implement some scheme, they don't really have the amount of autonomy the court thinks the founders wanted. I think more pragmatically, the concern is that if Congress wants to pass policies that have costs, and almost all policies have costs, right? Financial, bureaucratic, maybe political in terms of pissing some people off, you want the federal government to bear the costs of the policies that they create. Otherwise, it works like this. Congress passes a law. They say, look what we did, we're awesome. The states have to actually implement it. Any mistakes that happen, you blame the state for their bad implementation. The states actually have to raise taxes to deal with it. That's not great, right? And there's nothing more congressional than trying to shift accountability to someone else. And that's actually an area that's off topic, but one of the areas that I think Madison went wrong on checks and balances, what if Congress doesn't want to be powerful? They just want to be reelected and blame somebody else. It's a debate for a different day. So a couple of quick examples before we get to the issues at hand. There was a case in 1997 where this anti-commandeering doctrine is made most clear. And I don't know how many you remember, but in the mid-90s there was, before the Democrats lost control of Congress and Newt Gingrich comes in, you have an assault weapons ban. I don't like the term because assault weapon, like sanctuary cities, doesn't really mean much. But basically it was an attempt to place some limits on high magazine guns or guns perceived as dangerous. One of the aspects of that law was establishing a federal background check system. All right? Now here's the problem. There wasn't actually a federal background check system, and it wasn't clear how long it would be before one would be functioning. It's not clear to me one is currently functioning. But one of the areas where government does not seem to do terribly well with is technology. You probably read stories about this, like FBI spends money on system, can't implement it for 5 years, and then gives up on it. I don't know. Something, and we're not immune. Cal State Fullerton administration also has issues here and there with that. Don't tell anyone I said that, though. So in this particular law, what the US government did is they said, hey, while we are getting our background check system up and running, state and local, the term is chief law enforcement officers, so police chiefs, sheriffs, whatever your name is depending on your jurisdiction, you guys need to do the background checks for us until our system's up and running. Now in some sense, if your goal is to like get background checks going as soon as possible, it sounds reasonable. It's like a policy objective, right? You guys do it and then we'll come in and do it later. But you know, what if the feds never do it later? Then you basically told the states they have to do the job that the Congress should be doing through their own agencies. So a number of chief law enforcement officers, CLEOs, as the court calls them, sued. And of course, a lot of the lawsuit was based on cultural valences, maybe sheriffs more prone to be gun rights, NRA supporters. So it's not just about like federal power, it never is, right? No one wakes up in the morning like, federalism, bah. That's not what gets people going. But that's the basis in which the lawsuit was made, and the court agreed. The court said, look, you can't force the states to set up this background check system. If you want to do it, you have to do it yourself. They're not your servants. That's what commandeering is, right? When you force a state to do something that the federal government has the power to regulate but needs to do itself. Another more recent example of this, anyone like sports gambling? Again, not very good at it, but I like it. You probably are aware that up until very recently, most places in the United States, you could not legally gamble on sports. That's why people in my generation were running out online to the Caribbean or whatever and hoping that, you know, they sent us our money and we won. Now, interestingly, there's not actually a congressional agency that's running around shutting these things down necessarily. And there is DOJ weighs in here. But what was at issue was a 92 law, I believe, that basically told states they could not legalize gambling. It banned them from doing that. Now, if Congress had passed a comprehensive anti-gambling statute and regulated interstate commerce, and then California tried to conflict with that, California would probably lose at the court if there was a lawsuit, because federal law supersedes state law. But Congress really isn't getting involved here. They're basically saying, hey, states, you can't allow gambling, as a way of like sort of doing their job for them again. And just last year, the Supreme Court said, 6-3, I believe, that this can't happen, right? If Congress wants to get involved in prohibiting gambling, it needs to like pass a regulatory framework and not just tell states to prohibit it. So this is exciting for me. I get the chance to anger my wife different ways down the line when California creates sports books or whatever. Hopefully I'll be smart enough to stay away, but I don't know. Once the kids get through college, who knows? But these cases are actually very relevant for the immigration debate, as we'll see in a second, okay? Any questions on these two cases? Or the anti-commandeering principle?
Prohibition, good example, right?
Yeah, the prohibition involved, a constitutional amendment, and then after that, the 21st Amendment gave states a really high level, I'm sorry, I heard the voice, I didn't see the person. Prohibition, the 21st Amendment that repeals prohibition gives states a very high level of authority over liquor, like more so than one would otherwise expect. Yeah?
How does it affect drug laws?
So for drug laws, the federal government has a pretty well-developed regulatory system going back to 1969. Their own schedules, they have the DEA. But I didn't choose marijuana as our topic. I could have. It's another good one, right? But for a while in California, you had, marijuana is medically legal and now recreationally legal, but federally illegal. And what that basically means is that the feds can come in and arrest people if they want to, but they're not. Like the Obama administration said, we're just not going to do that. We'll see how it plays out. And then Sessions made a lot of noise about it, but as far as I know, like the biggest concern there is if I run a marijuana business and try to get a bank to loan me money, that's a problem because the feds can come in and they can fine you basically. Does that answer your question? Yeah.
Well, back there was a lot of debate about something called unfunded mandates.
Yes. And that's
square with anti
It's,
Was that never decided on a legal as opposed to political basis?
Could you repeat?
yes, so the question was about unfunded mandates and how that plays into what we're talking about here with anti-commandeering. Very central. Unfunded mandates was actually one of the justifications for the court's development of the anti-commandeering doctrine, where the feds might say, hey, we have environmental pollution sites here and there. States, clean those up. Thanks. Right? As opposed to like the federal government being the ones to pay for it and clean it up. And so you would see situations where the states would be like, you know, you need to do it yourselves, not tell us to do it and have us foot the bill. But that is definitely one of the driving forces behind this, is that it's not telling the federal government that it can't do something, it just has to do it itself, rather than rely on states to do it for it. Okay, so let's look at the first of our two big issues here. And the first one is grants and funding given to cities and localities. You probably already know this, but states and cities rely very heavily on federal money to operate their day-to-day business. Even a fairly wealthy state like California, I think, receives about 25% of its total budget from the federal government. For a state like Mississippi, it's closer to half. Right? And so what that means basically is that the federal government has a fair amount of power in giving this money out. So the grants, this is not the only grant at issue, but I think it's one of the biggest ones. And it's JAG stands for Justice Assistance Grant. It's not related to like, you know, the TV show JAG or anything. But it basically is money for criminal justice, police functions, things that are pretty central, in particular for cities, right? Bigger cities which need help with law enforcement and other issues. So you probably remember that Trump campaigned against the idea of sanctuary cities, which I'll just use as a shorthand for states and localities need to better cooperate with my tougher immigration policies. That's what I think he meant by that. And again, per the 10th Amendment, per anti-commandeering and other principles, you can't just order the states to do that. So Congress can't pass a law saying, California, please direct your local police officers to cooperate with us as much as we want. That's just not going to fly under the 10th Amendment. Now, what you can do, and what Congress has done for decades, especially since the New Deal, is put conditions on federal money. Right? And then once states and localities get used to that money, it becomes part of their baseline. And I think the analogy I use in class, which is not awesome, but I like to shake things up with the students. I say that, you know, states are addicted to federal money and the U.S. is the pusher. It's not great, but it works. They get it. And so, for example, if you're, you know, in order to receive federal funds as a private university, you have to abide by U.S. discrimination laws, for example, right? Schools that, K-12 schools that want money have to worry about race to the top or upside down or whatever their current education policy is, right? And so in class, in the field, we call this fiscal federalism. It's a way of basically bribing states to do what you can't order them to do. And one of the more famous examples of this in the Supreme Court area is a 1987 case called South Dakota versus Dole. Do you remember Mothers Against Drunk Driving? I'm assuming they still exist, right? Became a pretty potent political force in the mid-'80s, among other things, trying to get the drinking age raised from 18 to 21. And again, my students never imagined a world in which they could drink as freshmen, so some of them are sad about that. All doesn't seem to stop them anyway, so. So Congress passes a law, because again, Congress can't say, California, North Dakota, Louisiana, raise your drinking age. Right? You can't order a state to change its laws. That's against the 10th Amendment. So what do you do if you're Congress? You say, hey, you know what, states? You get a lot of highway money from us. This year, or this budget cycle, we're going to tie 10% of our highway money to whether or not you have raised your drinking age. And at least in theory, that keeps the state's sovereignty, because the state has a choice to say no, right? They can take the money, and then they have to do what the conditions on the money say, because it's not their money, it's the Fed's money. Or they can say no. Either way, they have a choice. Now, one of the big questions in this area is, when do they not really have a choice? And that's actually one of the things, side note, the court ruled with the Affordable Care Act is that Medicaid funding is so huge that it's not really a choice anymore. It's pressure, it's coercion. We'll put that aside for today. So this is something that the Trump administration tried to do. There was an executive order 13768. I'm not going to quiz you on that. But basically what it did, the Justice Department is the one that distributes a lot of these local and city grants for law enforcement and what have you. And what the Trump administration said was, from now on, if you want to keep getting these grants, you have to be abiding by our interpretation of U.S. immigration law, which sometimes is pretty specific and sometimes I'm not sure what the hell it's saying, to be honest. It's vague. Congress is vague sometimes. And so, in a number of cases, Santa Clara, California, Santa Clara County, I should say, Chicago, Philadelphia, challenged these lawsuits as being unconstitutional. Now, you might think that this would come down to a question about, is the federal government coercing the locality, or is it just giving them a tough choice they have to make? But it actually turns out that lower courts so far have gone a different tactic. And what they have said basically is that the only entity that can constitutionally control money is Congress. Congress has the power of the purse. So if Congress wants to write a law, a new law, that ties these grants to cooperation with immigration enforcement, that's fine. But what can't happen is the president coming in and kind of unilaterally changing the scope of how these grants apply. And the Trump administration particularly got in trouble here because these grants, the way they're written by Congress, don't give the Justice Department a lot of discretion. So the law doesn't say, hey, if you like Philadelphia, give them some money. It basically says, how, whatever percentage of population they have, how many police they have, here's their money. It's what we call formula-driven. So the lower courts here have said basically that this is a separation of powers issue. The Trump administration can't unilaterally change how the grants are given out. Right? And you have 3 cases where all the localities have won, and then 1 case has gone to the appeals court in the 7th Circuit, and Chicago won there too. I would guess this particular issue will not be taken up by the Supreme Court. Let's let the lower, because so far, one side has won everything, and the court often likes to weigh in when there's different answers in different parts of the country, because in theory, the Constitution means the same thing everywhere, no matter where you live. So, the takeaway from that is that if Congress wanted to pass laws that restricted the ability of, say, Los Angeles or San Diego or Chicago and limited how they could get their grants unless they did X, Congress could do that. Fortunately for these cities, Congress apparently can't do anything. And particularly now that Democrats control the House, the likelihood of a law like this being passed is basically 0. Right? If you were a Republican who wanted greater immigration enforcement, the time to do it was between 2016 and 2018 when you had control of all 3 branches. To me, that says that among a lot of Republicans, especially in the Senate, Trump's immigration policies are not actually their high priority. I think if they had been, they would have pushed it harder. That's my personal opinion, so feel free to disagree with that. So my guess is that this trying to pressure city and states by withholding money is not going to fly unless Republicans, 1, take control of all 3 branches of government again, and 2, make that a high priority, as opposed to, say, cutting taxes, which is what they actually focused on, right? Although I will tell you now that I did my taxes this week, and they were not cut. So I'm not real happy about that. Okay. The second thing I want to look at today is the steps that California has made and whether or not those are constitutional. And the answer here is yes and no.
Thank you.
You're welcome. That's what I call in class a Robinson answer, where I refuse to take a side and say that everyone has good points. But it's true sometimes, right? Well, here it's just that there's more than one issue, and the court has said some are okay and some aren't. So I shouldn't have text so small. I'm sorry. This is for me, not for you, so I don't forget what the laws are. But California has passed three of the most important laws that California has passed, kind of like as a middle finger to the Trump administration, probably. So let's go in order. Probably the most important one is Senate Bill 54, which had another name, something like Save Our Values California Act, or that's the sort of thing I should know giving the presentation. And I knew it yesterday and I forgot, apologies. But basically what this does is where California has told its own state and local law enforcement basically only to cooperate with ICE and what have you when they legally have to, when there's a warrant, when someone is a dangerous felon and there's a good reason to let ICE come in and do whatever. Otherwise, California law enforcement is not supposed to use resources to help the federal immigration agencies. They're not supposed to share any information, again, except what is required by like a warrant or court order or what have you. And they're not supposed to transfer individuals over to ICE without a warrant. So what this basically is doing, I'll get you 1 second, some localities don't want to anyway. Like I assume Los Angeles, for example. Other localities, like some in Orange County, probably would happily coordinate with immigration officials if given the chance. And what California is doing here is saying, doesn't matter if you want to, you can't. Yes?
In California legislation passed laws that do not further the California Constitution.
Can you be a little more specific?
Well, do the laws created have to apply with the powers that were stated in the Constitution? I mean, the defense had the same challenge you said earlier, is that if it isn't in the Constitution, you can't make a law about it.
So that's a good question. The federal government and the state governments are different in that regard. So the federal government, when it was specifically conceived as a limited but really powerful entity to solve the problems that states couldn't handle on their own, like commerce, like the military. One of the things we saw after the Revolutionary War, the Congress couldn't collect taxes. So it'd be like, hey, can we have some money for a military? And George would be like, not this year, sorry, we're broke. And so states, by contrast, are sovereign within their own borders. So if the US government wants to create some kind of vaccine requirement, they have to ground it in a power in Article 1, Section 8. California doesn't have to do that within their own borders.
So California can pass a law that constitutionality can't be ruled.
Well, I mean, California might have its own Bill of Rights, the US government has a Bill of Rights, and maybe the California law comes into conflict with the US law. But California is not tied to that, what we call, the fancy word is enumerated powers framework. They can, again, if they want to ban alcohol, let alcohol happen. It's a bad example because there's actually an amendment about that. California wants to legalize marijuana or criminalize it. They don't have to base it on something. If Congress wants to criminalize marijuana, and they have to tie it to their control of the marijuana market and say there's an interstate trade, illegal, in marijuana that we can control. So states actually have more authority to create policy within their own borders than the US does, on paper at least. In practice, the courts have let Congress do a lot since the 1930s. We're getting a bit off topic. That's one of the big debates in con law since the New Deal is how much should Congress be allowed to do? What should things like the Commerce Clause permit Congress to do, right? So that's Senate Bill 54, the idea that states and localities are not permitted to cooperate with immigration authorities, except where federal law is pretty clear they have to. Okay. The second bill, Assembly Bill 103, gives the Attorney General of California the ability to basically spend money, go in and review immigration detention facilities located inside state borders. right? Because there were some concerns, and again, I'm not an expert on immigration policy, so don't ask me how valid these things are. But there were concerns that some of the detention facilities were not up to state and local code. Maybe they were underfunded, or the detainees were being treated badly or not given proper medical care. Again, I don't know enough about the actual specifics to be an expert on this. Like I read the LA Times last month or something on this, right? So that's the argument on that. And then third and finally, and this is the one that has been struck down somewhat in court, a couple of the provisions. Assembly Bill 450, this is probably the most constitutionally uncertain because it doesn't just direct state officers, it tries to regulate businesses and consumers. And so 450 it talks about, it's a regulation of businesses in California. So businesses in California aren't allowed to consent to let Immigration and Customs come in their facility, right? So I don't know how many of you, probably not many of you are thinking about ways to avoid having like your car or house searched by the police. I expect you're mostly law-abiding citizens. But whether or not the police have the right or the authority to search your property, if you give them consent to, they can, right? I always tell my students, like, be careful. I had a police officer come by and said that they were investigating a murder and could they come to my house? And I was like, why? Do you think I did it? What's going on here? It was a long time ago. But businesses could consent if they wanted to, right? Maybe the person who owns the business feels that immigration policy should be carried out the way, for example, that Trump wants it, and they want to allow Immigration and Customs to come in. And what this law says they can't, unless, again, they're legally required to by a federal warrant or what have you. There is also a requirement that if ICE tells the employer they're going to come, which they do, they say, hey, we're going to have an inspection, that the business has to tell the employees as well. And like on one hand, you could say, well, if the employers know, why not the employees? On the other hand, it sounds like a way of trying to say, hey, cops are coming. And that's what the Trump administration alleges. That's basically a cynical way of trying to get around the law. And then third and finally, the law says that you're not allowed to, after you verify someone's employment status, the way that federal law requires, you can't do it again, right? Unless, again, federal law says you have to do it. And typically, I think you have to do it once, and then after that, it's kind of up to you. And so again, what these laws are doing basically is trying to restrict people who would want to cooperate with the Trump administration and saying you can't do that. That's kind of the theme underlying all these laws. But 1 and 3 is a little different. So any questions on these before we talk about the recent court case? Start drawing to a close. Okay, so all of these bills get challenged by the United States as impeding federal immigration efforts, or California is trying to regulate immigration and it can't do that, the same way that Arizona couldn't regulate immigration in 2012 by making it tougher on people in Arizona. So the case here, which was last June, I want to say, and it's actually all that's happened, I'll jump to the bottom, the United States requested an injunction on the law. And all that means is all these laws are frozen and don't go into operation until the courts have fully worked out whether they're constitutional or not. So for example, if California passes a law saying you can't criticize California politicians, you probably want to have that law enjoined right away rather than waiting 3 years for them to figure out what the rule is, right? Because in the meantime, you can't criticize anybody. So this is not uncommon when one body thinks another body is acting unconstitutionally. They say, whoa, wait a minute, freeze the law. And this has happened to the Trump administration several times on, for example, their travel ban, the first and second iterations. And the way this works, basically, if the court thinks that the government could reasonably win, they will enjoin it. If the court thinks the government is not going to win, they won't. So this isn't really a determination that the U.S. has lost or won, but kinda. Because if the court says, hey, you're not going to win on this, do you bother going ahead and trying again? You might, but you've kind of been told that you won't. The Trump administration basically said that by not helping, California is actually impeding. And it wants the court to come in and tell California it can't pass these laws because it's making it harder for the Trump administration to do the job of enforcing immigration as they think it should be enforced. It's actually a fairly tough issue. Again, when does not helping become impeding? The basic distinction that the district court here relied on is the same one we've already talked about. When California is directing its own officers to do something, it's on safer ground. When California starts regulating businesses and private citizens in the area of immigration, it's on shakier ground. And again, the opinion's like 90 pages, so I'm kind of easing that out a bit. But that's basically the bottom line here. Real quick, this slide is not actually should be after where it is, but that's okay. You probably remember that a fair number of localities, some in Orange County, basically didn't like these California laws we just discussed, and some of them, signed on as amici to the Trump position here, right? I have a picture of Huntington Beach and protest there that I found on Google in the 3 minutes I've had time to look for a photo. But a number of sheriffs and localities in the state were unhappy about the law, right? They don't have the political power to overturn it, but they did basically signal that they were with the Trump administration. Now again, this is all symbolic. Orange County or Huntington Beach or whoever have no independent authority to challenge California the way that California might have authority to challenge the United States. We don't have federalism inside California. Right? California is, they're in charge. Now, politically, you could push back and hope that you could win. And there was some effort, I think, by Republicans in 2018 to make this one of the issues that they highlighted. It didn't work very well, but that and the gas tax, I think, were two of their big issues. Okay. Well, the judge rules on each of these. We'll look at each one. The first thing the judge looks at is this law, this 54 law, and that's the one where California says police officers aren't supposed to be helping ICE do its job. And there's actually there's a pretty decent principled reason for this. Whether you agree with it or not is fine. But this isn't just Trump sucks. And that's where a lot of the political energy in California is coming from, the same way that Texas and Obama was. But the argument that big cities like Los Angeles make is if our undocumented community thinks we're going to turn everyone over to ICE, they're not going to report crimes to us. And we're going to end up spending time acting as immigration agents, which we're not trained to do, instead of time being cops. So it's a bad use of our resources. If we have to figure out, I don't know how many people Los Angeles detains on a daily basis, but probably thousands, right? I have no idea. More than 10 and less than 1 million, right? But California or LA might say, look, we don't have the resources to figure out whether every person we arrest or detain is a citizen or not. We're not set up to do that. We shouldn't have to be trying to keep track of all of that for ICE. That's their job. It's not ours. Right? Yeah, we're there. We're closer to the ground. Sorry, we don't want to do it. Right? So I think, you might disagree politically that that's the wrong stance, which is fine. And a lot of people do, obviously, in Orange County. But that's the basic argument that California is making here. And the court basically agrees with California on this. It says that California does have the right to direct its state and local law enforcement officials to do what California wants. And the court's not being asked to judge the wisdom of the policy. It's not the point. It's just the pure power structure. Now, the U.S. tries to finesse this by saying, hey, we're not commanding them to do things. We just want them to share some information with us. That's not really commandeering. That's just saying, give us some documents. And that has worked in a few other cases we're not going to look at. And what the district court says, well, the degree of information keeping and interaction you want, it's not just handing over a report. It's like a daily interaction, lots of work over time. And to the judge, that crosses over into being commandeering. I can see the Supreme Court seeing something different if this case gets up to the Supreme Court. But I think most lower courts are going to agree with that. And the court even quotes, there's a quote I put here in this, refusing to help is not impeding. Especially when it comes to the state's control of its own officers. And they say this case is not like the Arizona case. In the Arizona case, the state was trying to change what federal immigration standards are in Arizona. Here the state is just saying, do whatever you want, but not with our people. Now again, cynically you could say they are trying to thwart Trump's immigration policy by making it harder for ICE to do its job when they should cooperate. But that's a judgment up to the voters of California and not the Justice Department. Okay? Questions on that? And I think this is the most likely of California's laws to be upheld, because a conservative court on other grounds has upheld the anti-commandeering principle pretty regularly, and it would be a pretty stark reversal to just ditch that because it's not conservative states' rights, liberal federal government alignment.
This issue was very big recently in my job, and that is immigration ICE in the courthouses and invading the courthouses and watching.
In terms of like picking up people who, yeah.
Exactly, and that was a big issue that the Supreme Court justice had to deal with. When you're done with someone in your courtroom, outside they're arrested based on what happened in the courtroom, and it was having a chilling effect on the way we operated our court system.
Sure. And that's the judgment that this law makes politically, is that the state's job is to, be a law enforcement, protect people, citizens or not citizens, from crimes, and we can't do that if no one will talk to us or go to court or report to the police. By cooperating with the feds, it's making our jobs harder. And again, that might be right or wrong. I'm sympathetic to that idea, but it's the state's call either way. It's not the federal call. If you don't like that, you have to win more elections at the California level. Okay? Now the second law, which I would argue is probably the least important of the three, that's can the states review these immigration facilities? And the judge kind of says that depending on the facts, this might go a different way, but the judge says, as I understand this right now, simply letting the Attorney General go into a facility and look around is not impeding immigration efforts, right? It simply asks them to have access to the facility. And in fact, the judge says a lot of times when these agreements are written up, like the state of California and the feds contract with a provider, I don't know who actually runs immigration facilities, so forgive me, but that they're supposed to abide by state and local law. That's part of their actual contract. So the court says for the most part, as we see this law, this is not actually impeding federal immigration efforts. Now, I can imagine a weird hypo where the Attorney General visits a facility every day and makes it impossible for work to get done. It's kind of dumb, but it makes my point. It's possible to imagine oversight as harassment. And if that actually happened factually, then I think the United States would have a better case here. But if it's just we want to do an annual inspection and get reports that they may be entitled to anyway by contractual issues, the court says we don't see that as preempting federal immigration law or impeding federal immigration efforts. So a lot of how this case will turn out later and in future cases will depend on what the state of California actually does in its oversight. Okay. To what extent is that oversight, I don't know, crippling or just kind of normal good faith looking into stuff. Okay, last one. 450, most of 450 is struck down by the lower court. And the argument here is that by trying to regulate private businesses, you are in fact getting into the area of policy that Congress is supposed to be in charge of. You're no longer just telling your own state officials what to do, which is protected by the 10th Amendment. You're trying to regulate the same businesses that Congress is trying to regulate. And more specifically, the court says this: imagine a business person who the feds say, hey, we would like you to cooperate with us on immigration. The state says, no, you can't do that. That puts the business person kind of in a tough position, trying to understand which law or who they should listen to. And the court also says that the state law actually discriminates against the federal government. I'm trying to wrap my mind around this. Because if you choose to cooperate with federal officials, California is going to penalize you. And if you flip that argument around to if you let Justice Department officials into your business in Georgia in 1960 to check for civil rights violations, maybe the parallel becomes a little clearer in terms of why the court is not wild about this idea, right? The federal government is acting lawfully. You shouldn't make it harder for private businesses to voluntarily cooperate. Now you're starting to actually affect immigration enforcement. Similarly, the court says with the you only can check someone's verification for work status legality once, the court says that's not how federal law is written. Federal law doesn't say you can check it once and you're good. It says you're constantly liable for having workers that might be undocumented. If that's the case, it's not really fair to a business person to say, hey, you can check once, and if you're wrong, well, too bad, you're on the hook for federal law. And the court says no. If federal law says they're always liable, they should be able to check as often as they think they need to comply with that law. So in both these situations, California is potentially impeding or getting into the area of policy that the court thinks the Constitution leaves to Congress. And I'll get you in 1 second, sir. I do see you. Lastly, and I was a little surprised by this given the rest of the ruling on this part, but the court says that the last part of 450, the 72-hour notice, is okay. And the argument is, well, employers can already tell, employers know, why not employees? That's just traditional California regulation of labor law. Okay. I'm not sure how well those things fit together, but I don't envy the judge. There's a ton of moving parts here, and trying to make consistent themes in legal decisions is tough to do. Yes, sir.
Where does the prohibition prohibit landlords from asking immigration status? City of LA, I think, did try to landlords have.
Can you repeat that?
So I think he was asking whether or not, you said Los Angeles prohibits landlords from asking legal status?
They proposed a law that if you ask a representative for immigration status, that they're actually fined for leaving the real time.
Sure. So I guess I don't know, there's a lot I don't know. Do landlords have the same legal liability that employers do? Would be one question I would ask. Because employers really are on the hook for who they hire and operate. And I'm not sure landlords have the same liability, so that might change the situation of how the court affects that. But certainly if the court feels that, I mean, traditionally states can regulate rent and landlords and businesses. That's their traditional area of involvement. But I can see a court maybe making the same sort of ruling they did here, but I would need to know more about what federal immigration policy prohibits before I could feel comfortable in even making a good guess.
President Trump had a conniption over the Oakland mayor who warned people about an ICE raid. Would that fit into this?
I mean, it does in the sense that, and I don't, it's the same ballpark. I mean, here we're talking about forcing employers to tell employees, and there it's, I think she had access to the information, maybe as a courtesy. I'm not sure how she knew. I should know. I don't remember the story. I remember the story, but not that detail. That's just more of that's Trump's political reaction to why aren't you helping federal immigration agents do your job? Why are you trying to make it harder? It's again because they have very different views of what immigration enforcement should look like and what state and localities should do. But yeah, Trump didn't like any of these decisions. I mean, that's sort of how he rolls, right? He gets angry and goes on Twitter.
I think we have 2 minutes.
Okay.
If I'm an employer and I want to hire somebody, I have to have a social security number that I can pay the income tax to.
Mm-hmm.
So I'm now complying with federal law. So why should ICE come into my business and see if there's somebody there that's not?
Yeah. So as I understand the situation here, what this law is applying to is people in your situation who do want to give consent, and California is telling you you can't. I think you always had the ability to say no as a private business owner unless there is a warrant or a court order or some kind of legal process. But we're talking here about someone who, for whatever reason, says, yeah, ICE, come on in, look at my business, and California is saying, you're not allowed to give consent. Does that answer your...
Yeah, I guess, except that if a company's already complying with the federal law, why should ICE even want to put over the building?
So, again, I've never run a business like you. I've either been a worker or an employee or a faculty member. But my sense is maybe that Social Security numbers can be gotten illegally and or E-Verify does something different. And now you're getting into stuff that maybe I should know before giving this presentation, but I don't. I do the con law and I don't hire people to work for me. So it's a good question. I wish I had a better answer, but I don't. Yes, ma'am.
Well, the employer has to have an I-9 employee. The federal government can come in and check on that.
Okay. So maybe there's a concern that you're letting false I-9s go through, or you're just not paying any income tax at all. So maybe there's a presumption of good faith that ICE doesn't give all employers.
Hey, Professor Robertson, do you want to do a 1-minute summary?
1-minute summary. Sure. This is my actual last slide. So I'll say this. The debate could be changed quite a bit in policy terms by Congress. It's not going to happen because of the current partisan divide and because Congress has trouble doing anything right now anyway. I think it's pretty established by these lower court cases that the president can't just say no funds for you unless Congress has already written the grant so that it says, hey, you can deny funds to anyone you want. Almost no grants are written like that. I think these cases do show us that when blue states react to immigration policy, there are outer limits on what they're going to be able to do to regulate businesses, to tell them, no, you can't give consent. It also shows us, I think, though, when it comes to state control of state employees, that the 10th Amendment is still in effect and the anti-commandeering principle is going to control these cases. And I have Supreme Court question mark because I've learned better than to think I know what's going to happen once it hits the 9 people on the court. My guess today is that the anti-commandeering stuff would be upheld and that they might strike down the stuff that the lower court has already struck down in the 450. That's my best expert guess, but don't sportsbook your Supreme Court takes from me, folks.
Professor Robertson, thank you very much. That was very, very good. This is an example of how well this university is served by its faculty members. We appreciate
My pleasure.
your knowledge, your presentation, your willingness to come across campus to be with us. Thank you very much.
Pleasure. I appreciate an enthusiastic and attentive audience.
I also have some always blinking someplace in my car that I'll bring over and leave at your office. Thank you very much.